filing number FA 6708 of 2024. The learned counsel for the applicant prays for and is allowed time till 4th of February 25 to remove the surviving defects. Post on 6th.
Item 2, file number first appeal 7091 of 2024.
For what? Same order. Respondent is present. Give your appearance, please. Appellant, you also give your appearance. नाम अपना लिख के दीजिए.
From daily list for orders, item 1, first appeal 37 of 2022.
Nay, this one. Leadership, this is the first appeal arising out of money suit where I was the unsuccessful plaintiff. We had filed an application for additional evidence. So at an outset, I am pointing out this additional evidence application is required to be considered along with the main appeal in the final hearing.
We'll see
So
what
may I
is it.
request whether
Let us see what is it. What additional evidence are you seeking?
the IA number 2067 of 2024.
Yes.
I have enclosed all those documents which are proof of the fact that I did carry out work.
No document is enclosed for this. Objection on merits. Okay. This is
IA number 2067.
when was the suit filed?
Suit was filed
28 April 2012.
These documents were not available with you.
These documents were available.
Then
They were not filed. So
They
the
will
first
not
first two grounds will not be in my favor. It's only the third ground which may be considered. This that we are putting validation is supposed to be here. The third ground that validation may consider these documents as necessary for effective adjudication.
we just can't.
For pronouncing judgment, enabling the court to pronounce judgment to the satisfaction. So that can only happen if your ladyship considers each of these documents along with the reasons on which the suit has been dismissed.
No, we are not going to allow this kind of petition. These are absolutely money suit, commercial litigation. You are not an illiterate person. Then I don't need these documents to decide the case. Why should I?
That's what is the bottom line. If your ladyship feels that your ladyship does not require these documents, I'm
Show
on.
us in the petition what have you stated regarding the satisfaction of the court. What have you stated regarding to satisfy the court that these are required for.
Your ladyship for that things will automatically follow once your ladyship goes through the judgment.
Records have come. You can argue the case finally. When do you want to tell us? Records have already come.
Next week.
It's a money suit.
Next week.
Now let us see your IA. We'll decide the IA today.
That's what I was
Records
saying,
are
your
here.
ladyship. The IA has to be considered along with main hearing. So if your
What
ladyship is
where
hearing it
is
on
that
any
law
other
that
day,
it has to be considered along with the main hearing? Records are here. You point out.
your ladyship this judgment, this order will be kindly received. And both of us are one on that point.
I
My
don't know.
learned
You
friend
may
has
be
also
one.
filed an application on. Oh, please hear me. My learned friend has
You have also
an-
filed an application for
of-
additional evidence.
No, I have not filed.
Yes,
I have just
filed
filed a reply to the IA.
in which he also says, relying upon Supreme Court judgments, that it has to be considered by final hearing. And this is what one matter arose from here. This Honorable Court was pleased to consider otherwise and decide that additional evidence application, the Supreme Court has set it aside and remanded back the matter for consideration. It's a short one, you can give the other ones also. Please see the last paragraph of the first page. The division bench has committed two mistakes. They are the situation that we are faced with today was exactly the situation in that matter. I was conducting that matter.
So records are here, you can argue your case, what's the big deal about it?
I agree. I'm saying if your is hearing this appeal finally today, then yes. Otherwise, it may be fixed on any date next week.
You can start
I
it
will
right
be
now.
considered along with that next week.
That's right. You tell us, let us see what is the case about and let us see what is the additional evidence.
Yes,
We can
yes,
commence the
yes.
hearing right away.
Yes, please.
With the consent of the parties, the hearing of the case has been commenced and the interlocutory application is being considered.
In addition
The
to
records
final-
have already been
in addition to
received
the
from
final
the
hearing,
court.
it would have been better if it could be posted next week, subject to a leadership's kind
You
convenience.
see, we will post it. Let us see the
Or-
conclusions of the case. Let us figure out what is
Yes,
the
yes,
matter about.
yes, I
Let us
completely-
have a look at it.
I completely bow.
Right.
The
We are
judgment-
not going to decide it today.
I completely bow.
But let us see
I
the
want to-
contours.
Yes. Page 36.
वो रहेगा जो dictation में.
Page 36.
36. Let us see what was the plaint, what was the grievance. All these things. Let us
Yes,
have a
yes.
look at it.
Page 36.
We will not see it from the judgment. We will see from the records. It's a first appeal. You place the plaint.
The plaint has been exhibited. Peculiar process has been followed by the court.
Any prejudice caused you? You were the plaintiff or the defendant?
I was the plaintiff.
So you don't have any issues on that.
No,
It has been executed. Kindly let us have a look at the plaint and the kind of cause of action, etc.
Yes, please. Plaintiff begs to state as follows: the plaintiff firm, namely Techno, exposed a registered proprietary firm executing contractual work and providing engineering and consultancy services to various firms, contractors on the basis of remuneration as fixed and determined between the plaintiff firm and other contractors. Principal defendant Udia Brothers is a registered contractor of SAIL and was often awarded contract by SAIL BSL, Macon, so and other companies against the tender issued by them for execution of project for civil, structural, electrical and other works. Principal defendant was frantically in search of an experienced person through which they could compete in the SAIL BSL pro forma defendant. Tenders for project works where design, engineering, supply, erection, testing and commissioning are involved and could get the contract for such projects. The principal defendant approached to the plaintiff for the help of engineering and consultancy for the proper execution of the work and smooth running of its contract business, if any, awarded to the principal defendant by the SAIL BSL and other plants of SAIL on the basis of having the vast experience and knowledge of steel plant in India and abroad of the plaintiff for more than 36 years. Plaintiff became ready to provide technical know-how and assist technically to provide all backup and support to the principal defendant for the proper preparation of bids and performance on the project with his technical skill and knowledge. Subsequently, a tender was issued by tender notice number so-and-so. May I skip that? The principal defendant thereafter requested the plaintiff to assist the principal defendant in the aforesaid tender for preparation of the techno-commercial bids with his specialized skill and knowledge, and also requested for doing entire coordination for the above mentioned project between SAIL BSL, consultant CET and the principal defendant. The defendant also authorized the plaintiff to collect, submit tenders, drawings, letters, clarification points and or any other documents related to the above project. Principal defendant also authorized the plaintiff to attend opening of techno-commercial.
Just a moment.
Yes.
This authorization is pursuant to the tender or it is independent of tender?
It's seemingly general.
General.
Yes.
So this tender was floated, and you were what was the mode and manner of your engagement is not reflecting from para 6 and 7.
Yes, it will come later.
Please continue.
Plaintiff accordingly, on the basis of the discussion and the said authorization letter of the principal defendant, prepared and submitted the techno-commercial offer on behalf of the principal defendant. Plaintiff also prepared all techno-commercial clarifications and submitted the same to BSL as and when asked by BSL. During techno-commercial discussion which the plaintiff had with BSL, plaintiff emphasized the technical points for getting a chance for submission of revised price. Subsequently, plaintiff also issued a letter and a fax letter on behalf of the principal defendant to SAIL BSL, explaining the detailed reasons for getting chance for submission of revised price bid. Accordingly, the chance for submission of revised price bid was given by SAIL, and the competitive revised price was submitted, on the basis of which the principal defendant became L1, the lowest bidder. after completion of all tendering process, the principal defendant became technically and commercially suitable and also L1 in the price bid due to the expert knowledge of the plaintiff. Accordingly, the work order against the aforesaid tender was awarded to the principal defendant, while work order number so and so and the contract agreement so and so was signed on such and such date with a total contract value of 2,62,77,764 inclusive of taxes. It is further submitted that after the price bid, a MOU cum working agreement was
This agreement was between
between us, these two,
the plaintiff and the.
principal defendant.
All right. Continue.
In the above agreement, which was executed between the plaintiff and principal defendant, it was specifically mentioned in the terms and conditions of the aforesaid agreement, which is more fully described below for reference, that both parties mutually agreed to work together for preparation and submission of the techno-commercial bids, preparation and techno-commercial discussions, and submission of required clarification for the above mentioned project at Bokaro Steel Plant. And in case of award of the contract to them, they will take up detailed fabrication, design, dismantling, fabrication, supply, erection, execution of civil work, testing and commissioning of the BCB extension, and establishment of the performance guarantee parameters as per provision of the contract. Plaintiff and principal defendant, therefore, for good and valuable consideration and mutual promises intending to be legally bound, contained therein have agreed hereto in the said agreement as mentioned in Annexure 4 of this claim. As per clause 3 to 7 of the aforesaid agreement, plaintiff was to arrange design and engineering for the project and provide all technical supervision in the area of fabrication and erection of structural items and civil execution work as per mutual understanding. In clause 2 of the same agreement, it was clearly mentioned the details activities which were carried out by the plaintiff before signing the agreement on mutual discussion and understanding. It was also further mutually agreed in the said agreement inter alia that the plaintiff shall be responsible for all coordination work, correspondences, preparation and submission of bills, project monitoring and progressing and arrangement of drawings, arrangement of items, plants and equipments components from domestic sources at the most economical rates on behalf of the principal defendant. In clause 7 of the agreement has been clearly and specifically stipulated that the payment shall be released by BSL in the name of principal defendant, and the principal defendant immediately on receipt of the check issued by BSL shall in turn issue a check in the name of the plaintiff, which shall be equivalent to 15% of the value of the check issued by BSL after adjustment of the taxes, duties and miscellaneous expenses, and further that any expenditure made by the plaintiff in procurement of material or otherwise shall be reimbursed by the principal defendant. Now it is also relevant to mention here that clause 9 of the aforesaid agreement clearly stipulated that the MOU has been made in good understanding with both parties and shall be respected faithfully in its true spirit, and nobody will back out of in their commitment for any reason whatsoever may come. Respecting the agreement faithfully, plaintiff extended all services as per the stipulation in the agreement. In addition, kindly mark this gives the cause of action.
Yes.
Parasite. It is submitted that the plaintiff it is submitted by the plaintiff that when a check of rupees 40 lakhs and odd was released to the principal defendant by sale, the plaintiff sent his bill dated 10th November 2008 for rupees 2,15,000 to the principal defendant. Similarly, when the second and third bill was released to the principal defendant by sale for rupees 68 lakhs and 53 lakhs and odd, respectively, the plaintiff submitted his bill for rupees 10 lakhs and 10 lakhs and wide invoice number 20 January 2009 for rupees 7,95,000 respectively. But in spite of several requests and reminders by the plaintiff, the principal defendant only gave oral assurance but did not pay a single farthing to the plaintiff with the utter disregard to the terms and conditions of the aforesaid agreement dated 11/9/2000. Plaintiff thereafter was also entitled to get payment of rupees 10,55,793 against its fourth bill, wide invoice number 104, dated 30th April 2009, which was handed over to the principal defendant during discussion for settlement outside the court, when the payment already received by the principal defendant from BSL amounting to rupees 62 lakhs, and this fourth invoice of the plaintiff is also attached with, which is also due for payment to the plaintiff. Plaintiff further submits that the principal defendant received total sum of rupees 2 crores and odd from BSL on the basis of the invoices prepared and submitted in association with the plaintiff, and payment was released by sale on the basis of regular follow-up by the plaintiff. The documents which was issued by BSL after release of payment to principal defendant was received by the representatives of the plaintiff. It is worth mentioning that sale does not hand over the payment documents to any unauthorized person. In view of the agreement, the plaintiff ought to have received total 30 lakhs, for which invoices were submitted by the plaintiff on behalf of the principal defendant. But the principal defendant, in spite of the aforesaid submission of invoices by the plaintiff for the said due amount, failed to pay even a single farthing to the plaintiff, and even did not send any reply to plaintiff's various correspondences, completely ignoring the terms and conditions of the agreement dated 11 September 2007. One copy of the document related to payment issued by BSL, first RA bill to fourth RA bill, enclosed at Annexure 5, Mark A to D. Plaintiff seeing the malafide intention of the principal defendant sent a legal notice to the principal defendant by notice dated 27 January 2009 through Shri So Advocate, stating therein to make payment for the pending bills of the plaintiff, as aforesaid, failing which legal proceedings would be taken against the principal defendant. Principal defendant, in reply to the aforesaid legal notice of the plaintiff through their advocate letter dated 19 February 2009, clearly agreed to amicably resolve the issue across the table and also agreed to suitably compensate the plaintiff for their having provided technical know-how. The principal defendant also requested the plaintiff not to go for any legal action.
We have seen the course of action. Now the entire story is that the principal defendant entered into an agreement with pro forma defendant, and there was an agreement that principal defendant will pay you certain amount for whatever work you have been doing, some percentage, and upon receipt of that he did not give you any payment. That is your cause of action. The matter was sent to permanent Lok Adalat also, ultimately nothing materialized. So he is for the principal defendant. And you are for the? What about sale? They filed their written statement? Sale
had filed.
Filed their written
Sale had
statement?
filed.
Who is appearing for sale?
Notice was issued.
Respondent number 3, Manoj, in this.
1 to 3. Notice validly served. Nobody has entered appearance. We will forget them if they are not appearing. That's their problem. Respondent number 1 appeared through Wakalatnama. Respondent number 3 validly served. Records received. If, as it is, they are pro forma respondents. They are not interested. We don't bother about it. Okay.
They have nothing to lose either this way or that.
That's right. They have already made their payment. Let us see what was the written statement of and what was the let's just a bird's eye view of the stand of the of sale.
Stand of sale is very short. Stand is that it is between them, because sale doesn't recognize. I just may read out the written statement of sale first.
Yes,
It's a very
let's
short
just
one.
find it out.
Yes,
What
it's
is
just
the
very
where they
short.
objecting?
From the plaint, it would be evident, according to sales statement I am reading, paragraph 5. From the plaint, it will be evident that the plaintiff has occasionally represented defendant number 1 before defendant number 2 as their authorized representative agent, without there being
A
any
neutral
contractual
party.
relationship between plaintiff.
Apparently a neutral party. They are not bothered about your relationship.
Actually,
Okay. Otherwise, they don't have any
the
technical
fact,
objection.
fact of the matter is, apart from this, in many other contracts also I gave the similar services and they paid. But
No,
that can't help me.
that will not.
I'm just
help
giving
you.
this is the fact.
That's right.
And that is why the matter was sent to permanent Lok Adalat, and problem is your leadership. Somehow, I don't know how things were dealt with. What the documents which were placed before the permanent Lok Adalat, they were not reduced in evidence. When the matter failed before permanent Lok Adalat, ideally, then in trial those documents should have been reduced. They were missed out.
No. permanent Lok Adalat is technically not a
Court.
court.
Yes.
And
So there's no contentions to be decided.
No
But
contentions
these
to be
documents were
decided.
placed in order to get a persuasion on the parties to settle the matter. These documents were placed. It is those documents which are being now sought to be adduced by additional evidence. I must say it very frankly because I cannot be running away from the fact that these documents were very much conscious possession of the plaintiff. And that is why at an outset only I said that first two clauses of Order 41 Rule 27 will not help. The written statement of contesting defendant, that is defendant number 1.
They are also saying that the documents filed before permanent Lok Adalat was forged and fabricated. Para 33 of the written statement. They are also saying that those documents are forged and fabricated. So it is, these are not admitted documents.
Therefore, frankly speaking, my additional evidence application can stand only if I am able to persuade the court to appreciate that these evidences are addressing the main issue, are going to the root of the matter.
Let us see what documents are you trying to produce.
But I am extremely inclined to make the submission that let it be heard on some other date when I will be arguing on the entire thing with a different frame of mind.
Let us have a look at it. What is it that you want to do? These are all letters. There is no the agreement the agreement was exhibited.
Yes.
Exhibit 5.
I have failed this. I have been non-suited on the count that I have not been able to prove that I actually carried out work for them. Agreement is not denied, but whether I have performed any obligation pursuant to the agreement was the moot question.
Yes, sir.
Only then I am entitled for consideration. I have been non-suited on that.
And this document, let us annexure A is what?
A.
Yes. What is the relevance? You just tell us the relevance of each document. We can partly allow also, isn't it? What is the relevance of annexure A?
This is the list of 14 drawings which were issued by Bokaro Steel Limited, collected by us and handed over to the private agency, namely Struck Mech Engineers for detailed design and engineering, which was received from Struck Mech Engineering with original bills and finally given to the defendants.
No, I don't get it. This is just a list. How is it relevant? And what is the for additional evidence? The original should be there, no? What is it?
For additional evidence.
Yes, of course.
I'm craving leave that I'll place all the originals before the court.
Let us have you bring the original. We'll see all the originals. You bring the originals. Without originals, we will not even permit any kind of additional evidence.
I've made a statement to that effect.
Sure.
So they will repeat me next week.
And what is the relevance? I want to see the relevance of each page.
Each page, nothing should go in the garb of something actually worth going. Nothing which is not worth it should go. As an officer of the court, I completely know. That's my duty.
Just place one
That's my duty.
judgment which covers the entire principle of law and this
Yes.
issue.
2015.
So, the principle is first the additional evidence should not be allowed if they fulfill the lacuna in their evidence.
That's right.
Second, my lords, the Honorable Supreme Court says, my lords, at para 16 of this judgment, that the true test for the court to allow additional evidence is whether the appellate court is able to pronounce the judgment on the materials before it without taking into consideration the additional evidence sought. So if my lords can decide the appeal without taking the evidence, additional evidence. Matlab
So
then
it is the call of the court whether the court is able to pronounce a judgment or not.
indeed.
If the court
Without-
finds that the court is unable to produce,
Indeed.
Your ladyship, that has been qualified by another expression. That court's ability to pronounce a judgment means court's ability to pronounce judgment to its satisfaction.
certainly.
So that is what is
Court
important.
will always
Court's
pronounce
satisfaction is
judgments on
always from the
satisfaction.
consideration of justice.
And my lords, my learned
Therefore, your
friends-
ladyship's questions are actually meeting that aspect.
You have not seen that judgment. In first appeal, we have passed a detailed judgment on additional evidence. That matter is sub judice before the Supreme Court in the matter of land acquisition matter, where we did not allow notification to be exhibited as additional evidence. That is pending. But all the judgments and
So
all
your
the
ladyship
angles
must
have
have
been
considered
taken.
all the judgments. of
I
the
have
Supreme
considered all the judgments.
Court. I'll check that.
I have considered all the judgments, and in that case, we have also taken into consideration if the documents we have held. I think, as I remotely remember, that we have held that that was an afterthought. I have considered all the judgments. You can just have a look at it. And basic principle is that it cannot be used to fill up the lacuna.
But your ladyship, that is so far as the first two grounds are concerned. The third one is regardless of parties. What parties are doing or not
And
doing.
additional evidence will be considered only when you produce the original.
Right.
Because these appears to be photocopies from certain documents. And then you have to produce the originals. It is not your case that you will ask the court to call upon anybody else to produce these documents. That is not your case. Right? That is not your case. So you should be in possession of all these original
I should be in the possession of document in whatever form I want to produce them in
you
evidence.
can't, you see.
Suppose secondary evidence is allowed in some case.
No,
Secondary
no,
evidence.
it is not your case that you want to adduce secondary evidence. You say that these are the documents which you want to exhibit. So you
So
stick
while,
to your petition.
while considering each document whether they should be exhibited or not, you will consider whether it can be exhibited or not.
No.
It can be exhibited if secondary
No,
evidence.
that
will
the
be
law
allowed
is
by
also
secondary
there that at a time of adducing additional evidence, the original is to be there before the court.
Ladyship only in those cases where original exists. Suppose
That is not
by
your-
virtue of circumstances.
Just a moment. That is not your case in the additional evidence. That you are not in possession of original. And when you say attested to be original, attested means what? You attest it only with respect to the original. Merely because you
Let me
say
see.
it is attested, this attestation has a huge meaning. Read पे तो कुछ भी लोग attest करते थे true to be original. We can call upon any advocate to say how do you justify this true to be original.
In fact, there is an
So
undertaking
ये
by them.
first appeal में ये सब नहीं चलेगा. Read नहीं
No,
चल
no, I
रहा.
have said I will.
There is an undertaking by them at para 5 of the
Ah,
IA
yes.
that they will produce.
That वो तो mechanical होता है
And
ना.
no. I have said that.
To produce it.
And I have said that in my appeal memo also. Whatever documents we have produced, in fact, your ladyship will find this IA for additional evidence is not an afterthought. It was there ab initio since I drafted the appeal. In my appeal memo, ground number T onwards is about these evidences.
Ground number T.
Yes.
And then
Page 20.
and then these additional evidence whatever you are trying to produce has to have some foundation in the has to have some foundation in your pleadings. Right?
So,
You cannot.
so as to satisfy
Yes.
the principle
So we
that
will see
evidence
the plain
can.
and the written
I
statement.
get it.
Whether these additional
I get
evidence, is there any indication of all these
No,
whatever?
Evidence, golden rule of pleading is plead facts, don't plead law, don't plead evidence.
Yeah.
So we don't plead evidence, but evidence must be in support of some fact which is plead. The fact is that I have worked. These are the evidences.
No, but this is not something which you say you want to
The
prove.
main problem is how to adduce them when we have missed it.
No, that is
Ladyship,
not
I
the
know
only
it's a
problem.
huge-
The other problem is that you have to produce because you say attested, you say original will be produced, you produce the original.
Just one submission. Because my learned friend has stated that in the interim judgment they have been non-suited only for the reason they failed to prove that they had rendered the
Sorry,
services.
also a
Malas,
limitation.
which is not the case. Malas, they have been non-suited because the suit is time barred. But they have also been non-suited because the MOU under which they are seeking the payment was already terminated within a month's time by the defendant. So these are two crucial
that's
things
an
for
in-
which, let me complete, sir. For which the additional evidence is not on record. So my lords can decide the appeal even otherwise without the additional evidence on these two grounds. That it is barred by limitation and the MOU under which they are claiming payment was already terminated and it is proved. It is exhibit B.
ठीक है. Further लिखिएगा. You were taking dictation? You continue. The counsel for the petition appellant and the respondent number 1
Minus.
have placed the plaint and the written statement and have also placed the IA number 2067 of 2024. During the course of, in order to consider the interlocutory application along with the first appeal, this court directs the appellant to produce the originals which have been annexed along with the interlocutory application. As only attested copy of the same have been produced. कहाँ लिखे हैं? They have undertaken.
Para 5 minutes.
And in paragraph 5 of the interlocutory application, the appellant has undertaken to file the original copies of the aforesaid documents as and when required. बताइए कब? Okay. Third is a holiday. Yes. When do you want to tell us?
Could it be the
Third के पहले.
week next to that, 10th or 11th?
Next week आप बोल रहे थे ना, next week produce करेंगे.
चूंकि ओरिजिनल प्रोड्यूस करना है,
तो
my client is very old, perhaps he is undergoing treatment in Pune. Therefore, I was playing safe. Tenth, 11th if possible.
नहीं इतना लंबा डेट नहीं देंगे. पहले next week रखते हैं. Find it out. Right. Post on 24th in the supplementary justice for further hearing. उसमें लिखिएगा आप भी जो भी जजमेंट्स आपको प्रोड्यूस करना आप कर देंगे पहले से. ये रेस्पोंडेंट. हाँ फ्राइडे. वो जजमेंट जरा देखिएगा.
जी जी.
फॉर फाइनल हियरिंग. हेडिंग अब चेंज हो जाएगा ना. हाँ फाइनल डिस्पोजल. उनको भाई सेल को बता देंगे आप. Mr. Indrajit Sinha normally appears. Formal appearance is सही. They should take it.
फ्राइडे की जगह पर थर्सडे को रखा जाए 23rd.
ठीक है 23rd को. 23rd को सप्लीमेंट्री. इतना है. और क्या है? आपका मैटर है. We need to rise. There is a full court now. फिर कैसे कब करना है बताइए. कोई मैटर अर्जेंट है तो बताइए. ठीक है. इट विल कम ऑटोमेटिकली. हम लोग अपने हिसाब से डेट दे देंगे. डेट आपको वो कंप्यूटर में पता लग जाएगा. ठीक है. आप अपने हिसाब से